Hello and welcome. I'm Jamie Hopkins. I'm the Director of Retirement Research here at Carson Group. And this is one of my rewirement tips on a topic that I just love. And this is digital estate planning. Now, you might have heard me talk about digital assets in the past, and I've written a lot on this, but digital estate planning is really that process that we take around our digital assets, our websites, our emails, our Facebook, right? Our online Bitcoin and cryptocurrencies. How do we take all those online present and put it into an estate plan? Because one thing that a lot of people don't understand is that traditional estate planning techniques don't necessarily work. That traditional wills, trusts, powers of attorney actually need to be updated because about 2 years ago, a law was passed in almost every state called RUFADA, the Revised Uniform Fiduciary Access to Digital Asset Act. I know it just rolls right off the tongue. Well, RUFADA, what it said in there is that we cannot change ownership of digital assets. And that's important because when you clicked on that, what we call terms of service agreement, and you scrolled down to the bottom as fast as humanly possible and said, I accept, I agree to get into your account, you agreed to a whole bunch of stuff. And one of the things you agreed to is that that account is a lifetime limited lease and is non-transferable, meaning that you cannot leave that to your children, your spouse, your grandchildren. If it's in your name, it essentially dies when you die. However, it's online, so it never really goes away. So we have this permanent digital footprint that we can't pass along. Well, RUFADA came in and states started passing this because more and more people are dying with digital assets. And what RUFADA said is you need to be able to, in your will, in your power of attorney, in your trust documents, specifically have language in there that says digital assets, and that you provide your executor, your trustee, your fiduciary access to manage, dispose, and handle your digital assets. If not, RUFADA says we revert essentially back to those terms of service agreements, which means your family members, executors, etc., don't have access. So you have to update your estate planning documents. I mean, it's a requirement. It's really not optional when I tell people this. You have to do it. The law changed 2 years ago and people haven't done it. And so that's a great way to engage clients to make sure you're adding that value, going back and saying, look, we need to review these documents. We need to get the right language in here because the laws changed 2 years ago. And a lot of people just don't know that this happened yet. So, hopefully you watch this, you learn something about it, you go out and you act. And if you're talking to attorneys, bring up RUFADA and fiduciary access to digital assets. You need to add that language into your estate planning documents.